Mr. Allen, case of Waters.
That's right. My lords, I outlined the factual basis for this. If you recall, lots of minor acts against this policewoman, and what she essentially wanted to be able to assert was that there was a duty of care owed by the Commissioner to her in relation to the workplace. And the case was struck out at first instance by the Master. Eventually, the contention was accepted in the Court of Appeal that a duty equivalent to that owed by an employer to an employee was accepted by Lord Justice Evans. But the policy reasons were advanced in the Court of Appeal for not permitting her to sue. The Commissioner sought to undo the progress that had been made by Miss Waters in the Court of Appeal, but also to stand up the policy defence. And the principal judgment was given by Lord Slynn. The judgment starts at page 1066, and at E on page 1067, the principal claim raised in the action is one of negligence. The employer failed to exercise due care to look after his, quotes, employee. And then, generically, many of the acts alleged can be seen as a form of bullying. The employer of those to whom he delegated the responsibilities for running his organisation should have taken steps to stop it, to protect the employee from it. They failed to do so. So the question was whether such a duty of care was owed. You see the question posed on the following page at C. The main question is thus whether it's plain and obvious that no duty of care can be owed to the plaintiff by the defendant on the facts alleged here. Then the employment context is developed between C and F, and Lord Slynn, citing his own judgment, I think, in Spring and Guardian, in the context of the employee, and then has no difficulty at H in saying, on the basis of these cases, subject to consideration of one overriding point. I don't find it possible to say, any more than Lord Justice Evans was prepared to say, that this is a plain and obvious case that no duty analogous to an employer's duty of care can exist, and that the injury to the plaintiff was not foreseeable in the circumstances, and that these acts alleged could not be the cause of damage. Then the policy point is addressed at B, and essentially there was a line of authority that said that, culminating in Calverley's case, in which it had been said by the House that there was no duty of care in relation to police disciplinary regulations. And the Commissioner sought to argue by extension from that the policy argument should go into cases such as this. And that's rejected by Lord Slynn at the foot of 1070 at H. I don't consider that either of these cases is conclusive against the plaintiff in the present case. It's true that one of her complaints is the failure to investigate the assault on her. There was a small assault, and that if taken alone would not constitute a viable cause of action. But the complaints she makes go much wider than this, and she is in any event not suing as a member of the public, but as someone in an employment relationship with the defendant. Even the failure to investigate is part of her complaint as to that, entirely different factors as to those that arose in Hill.
Do we get a great deal from this case? I mean, they were merely concerned with whether there was an arguable point.
Well, that, my lord, is at least a fair point. But the full details of establishing a duty of care, of course, require a little bit more than this. But I take it no more than this, that the mere fact that somebody is an office holder and not an employee in historic sense as of a police officer doesn't stop them being treated as inequivalent to an employment relationship. It's a negative point, perhaps, not dispositive, but it's part of the development of the law that we're going to see. The next case that I wanted to show you, in fact, perhaps if I can just, before you close that, you can see that part of the reasoning also developed from the well-known case of Frost and the Chief Constable and Lord Staines's judgment in that, at 1074, between F and G. But much closer to home to this case is Percival Price, which is at tab 23 in bundle 2. I'm about to get to Percy and the Church of Scotland, so I shall take this very quickly because it's also cited within Percy. The issue in Percival Price and the Department of Economic Development concerned the question, essentially, whether equal pay cases could be brought by 3 judicial office holders in Northern Ireland. If one turns to to paragraph 5 on the second page of the judgment, their facts are identified. Mrs. Mayo Price was the full-time chairman of the industrial tribunals. Mrs. Monica Davey was a full-time chairman of industrial tribunals at 8, and Mrs. Brown was a full-time chairman of social security appeal tribunals. And they wished to assert that they had been paid less and had conditions of service which are different and less than comparable males. Article 119 was relied on, which is at paragraph 21. Each member state shall, during the first stage, ensure and subsequently maintain the application of the principle that men and women should receive equal pay for equal work. For the purposes of this article, pay means the ordinary basic or minimum wage or salary, and any other consideration in cash or in kind which the worker receives directly or indirectly in respect of his employment from his employer. And in paragraph 25, under their cross-heading, are the respondents' workers. Essentially, what the court had to decide was the reach of Article 119, whether the equal pay principle went as far as judges. That was the question, essentially. In order to come within the provisions of community law, to which we've referred, the applicants have to establish that in community law they'd be classed as workers who are in employment, those 2 words coming out of Article 119. The Court of Justice has declared that the term workers has a community meaning in the context of Article 48, that's the old free movement of workers provision, and may not be interpreted differently by national legislation. See paragraph 16 of Laurie Blum. Criterion for application of Article 48, as the court said, paragraph 15 of the judgment, is the existence of an employment relationship regardless of the legal nature of that relationship and its purpose. He went on to say that concept must be defined in accordance with objective criteria which distinguish the employment relationship by reference to the rights and duties of the persons concerned. The essential feature of an employment relationship, however, is that for a certain period of time, a person performs services for and under the direction of another person, in return for which he receives remuneration.
Is there a question of degree there? Obviously, you can't be directed as what your judgment is to be, no. But you can be directed as to where you're to sit and what the times of sittings are to be and things of that kind.
Absolutely.
And be trained and
yes.
So on and so forth.
And there are many, the fact that independent judgment has to be exercised by somebody is not inconsistent with employment. There are many local government officers, for instance, who have a statutory obligation to exercise independent judgment, from reporting officers in local government to people making decisions, for instance, about parking fines and so on. And there are many different kinds of jobs, or people, for instance, who decide whether you've passed your test to be permitted to drive on the road. Clearly, the mere fact that there has to be an independence and impartiality in part of the job, indeed even a core part of the job, is not inconsistent with doing that job for the government or for the state, how one wants to put it. In 26, counsel for the appellants correctly pointed out that the term worker is capable of bearing a different meaning in different parts of the treaty and in other community legislation. We do not see any compelling reason, however, why it should have a narrower meaning in the context of equality of pay and opportunity than that which it bears in the context of the free movement of workers. The object of 119 and the directives is to give protection against inequality and discrimination to those who may be vulnerable to exploitation. The term workers should be construed purposively, as the tribunal held, by reference to the object of the legislation. In the course of the argument before us, emphasis was laid on the extent to which the respondents and holders of judicial office in general could be said to be under the direction of another person, my Lord Hope's point. We consider that the differences in the formality of expression of the terms and conditions of service and the extent of administrative direction of their patterns of work are not conclusive as criteria, for they reflect only differences in emphasis in the way that the same conditions are expressed. All judges, at whatever level, share certain common characteristics. They must enjoy independence of decision without direction. while the respondents quite rightly defended, as an essential part of their work. They all need some organisation of their sittings, whether it be prescribed by the president of the IT or the court services, or more loosely arranged in collegiate fashion between the judges of a particular court. All expected to work during defined times and periods, whether they be rigidly laid down or managed by the judges themselves with a greater degree of flexibility. They are not free agents to work as and when they choose, as are self-employed persons. Their office accordingly partakes of some of the characteristics of employment as servants of the state, even though as office holders they do not come within the definition of employment in domestic law. Now, the contrary had not been argued in this case, but even so, that, we submit, is enough for us to say there is an employment relationship, even if there is not, in fact, a contract of employment. This issue has not, to our knowledge, been the subject of any decided case in our domestic law. It was considered by the Court of Session in Stevenson and the Lord Advocate, and the Lord Ordinary expressed the opinion, with some caution, that a sheriff might constitute a worker. On appeal, the First Division decided the matter without determining the issue. The tribunal in the present case took the view that the term worker in the context of community law must be interpreted broadly and in a purposive fashion, an approach with which we agree. The object of the community legislation, protection against inequality of treatment or discrimination, seems to us to require the inclusion within the definition of all persons who are engaged in a relationship which is broadly that of employment rather than being self-employed or independent contractors. This being so, we are of the opinion that respondents come within the terms of Article 119 and the directives as workers in employment. Now, I pause there for a second, because, of course, the issue in this case, unquestionably, was whether Article 119 applied. That was the issue. But what one gets out of it is that, really, it became impossible in Sir Robert Carswell's judgment to conclude that there wasn't something that looked very like employment that judges were involved in.
It's quite an interesting contrast, isn't it, to say, well, what are they? And to say they're self-employed isn't really compatible with the way in which they're being required to work, or to say they're independent contractors because of the element of regulation that's inherent in running the court system.
Yes, absolutely so. I mean, it is a degree of control, albeit there is no control over the content of the judgment. But even that must be qualified. For instance, I'm sure that at least one member of this court at some time may have had to say that a judgment has been delivered too late, or there are rules about how quickly judgments ought to be set out. Certainly in the employment context, employment tribunal judges are expected to deliver judgments within a defined period of time or explain themselves. Sometimes they can explain themselves because it's impossible to do that. But there are a variety of rules like this which the court will be familiar with about how the business of judging, the work of judging, is to be done. And I don't need to do more than adumbrate them to make the point that there is a control over the way judicial work is done. Not going so far as to prevent independence and impartiality, but to make sure that the job gets done, bluntly. So, and there are many other examples of this by way of the training that goes into it, the obligation for continuing training, and indeed, to some extent, the way in which not administrative rules or rules which are on the edge of legal rules, such as, for instance, sentencing guidelines or the JSB guidelines and so on, define to an extent the context within which the work is done.
What's the respondent's position in relation to, for example, claims for pay, or claims, suppose there is a dispute about maternity pay, or the right to maternity leave and so on?
Maternity pay would normally be dealt with in the employment tribunal, being a statutory right. Yeah. But your prior point is how would they address the question of claims to pay? I don't know the answer to that, but I do know
but the terms might give better rights than the statutory ones for maternity pay and the like. In fact, they do.
Then, my lady, you're ahead of me because I hadn't spotted that point. But even so, to answer my Lord's point, Lord Diplock had no difficulty at all in saying that in a Privy Council case, a judge could sue in an ordinary way for claims in relation to wages. And I'll show you that case in a moment. it's not, I think, there is no example of it that I can put my finger on where a judge has sued for wages directly. But we'll get to those cases in a moment, if I may. Do you want me to go out of turn to them?
No.
But anyway, that's Percival Price, essentially, the ratio of it. There is no doubt at all that one of the legislative reasons for the inclusion of Regulation 17 was Percival Price. We know that. And indeed, the Court of Appeal thought it was part of the archaeology for the way Regulation 17 was included. When the part-time workers regulations were first published in draft for consultation, Regulation 17 was not included. It was not included in the draft provision. And Percival Price came out, and thereafter, when presented, they were included.
The history is given in the Court of Appeal, paragraph 43, I think, isn't it?
I say it's one of the reasons because the industry of Mr. O'Brien, through the use of the Freedom of Information Act, suggests that actually the LCD was well aware of the potential risk that the regulations would govern part-time workers from the outset. And I perhaps worth just showing you one letter that we have in part 2, in appendix part 2. Perhaps we just need a few dates here. The date of the judgment in Percival Price is, somebody can help me with this.
Not easy to find. It's in 2000 sometime.
It's 12th of April 2000.
Is it? Right.
And
Yes.
If one turns to page 68 in the appendix part 2, we have Lord Irvine writing to Stephen Byers, then Secretary of State for the Trade and Industry. And it was the Secretary of State for Trade and Industry who made the regulations, the part-time workers regulations. Thank you for sending me a copy of your letter of the 8th of November. I don't have any comments to make on the detail of your proposals, but there's one general question which I must raise. The question is whether the draft regulations would apply to holders of part-time judicial office. I'm anxious that they should not do so. I do not think this question need hold up the publication of your proposals, but it's one which I will wish to see resolved before the regulations are finalised. These judicial office holders who are currently described as part-time are not part-timers in the sense which is, I believe, the focus of your proposals. They do not hold a permanent or salaried office. Rather, they're called upon to sit for a relatively small number of days per year, typically between 20 and 50, and when required, and they're paid a daily fee for the days on which they sit. We would have assumed in the past that these people would not come within the ambit of regulations such as you are proposing. They are office holders rather than employees. They do not have contracts of employment, at least not of an explicit nature, and they do not appear to fall within the ambit of Crown employment. However, we're currently facing claims that the working time regulations, in which the definition of worker is admittedly somewhat wider than that of employee in your new draft regulations, do in fact apply to part-time judicial office holders. At least a possibility that these claims will succeed. Therefore, conscious of the need to put the same question beyond doubt in your new regulations if we can do so. And I should accordingly be grateful if you would consider whether the regulations would include an explicit exemption for daily fee-paid judicial office holders. I suggest that such an exemption could perhaps be expressed in terms of judicial office holders who do not hold office on a salaried basis. And I should emphasise that I don't question the validity and importance of the measures, simply don't think there's ever been any intention they should apply to daily fee-paid judicial office holders, and I do not wish to let that situation arise by default. It's interesting, the letter itself, because the ambiguity is patent in his own correspondence. He recognises that the working time regulations might cover them. He recognises that there is an ambiguity about the nature of office holders and employees. He could hardly have done otherwise, having been counsel in Miles and Wakefield. Puts the point is that they don't have contracts of employment, at least not of an explicit nature. Now, of course, that's a political document, will have been written by a civil servant, but no doubt Lord Irvine would have thought about it carefully. But that explains in part how Regulation 17 came to be added later on. There's more correspondence, but I don't take you through all of that at the moment. And the detail of it is set out in Annex, no it's not, it's set out in the part 4 of our submissions, starting at page 72, at paragraph 261, and going onwards. But I really don't have time to go through all of that, and I think you wouldn't be glad if I did, if I need to get on to Percy. So that shows the importance of the approach taken by the Lord Chief Justice, as he then was, Sir Robert Carswell, in Northern Ireland, and that's been generally accepted to be the case. There was no appeal to the House of Lords from Percival Price. The next case of importance after that was the Percy case, Percy and the Board of National Mission, which is at tab 24 in the bundle 2 of the authorities. And two of your lordships, my lord and my lady, were in this case. I do invite you also to note that Lord Nichols was in this case, because when I come to the Matthews case, Lord Nichols was also in the Matthews case as well. And in fact, Matthews was argued a mere month after judgment was given in Percy. The issue in Percy was whether a minister in the Church of Scotland could complain under the Sex Discrimination Act. The context was this, that she had been appointed to a manse in the east of Scotland. There was an allegation that she'd had an affair with a member of the congregation. She was going to be subject to church disciplinary proceedings, and she resigned and brought proceedings. And there were really two issues. The first issue was whether, within the extended definition of employment in the sex discrimination legislation, she could claim that she was an employee of the church. And the second issue was whether the provisions of the Church of Scotland Act of 1921 were such that the church itself had exclusive disciplinary jurisdiction, and therefore the Sex Discrimination Act could not be invoked to review the treatment that she had received. Now, in order to summarise the point, essentially all their lordships, save for Lord Hoffman, concluded that she had a contract of employment on the extended basis. Lord Hoffman said that there was no intention to create legal relations, but that was not a view taken by any of the others of their lordships. And on the second point, the principal judgment was that of Lord Hope, I'm sure you won't forget it, in which he concluded that the effect of the Church of Scotland Act was not to exclude the jurisdiction of the Employment Tribunal under the Sex Discrimination Act to review the question of whether there had been discrimination.
Lord Hoffman's paragraph 66 really puts his point. He said they were the duties of an office, not of anything else.
And we've cited it in our case because we felt, in fairness, we should do that. And we started in 62 and then it goes through to 66. But essentially, if your lordships would perhaps pick up my Lord Hoffman's reasoning, which starts at 62, I don't think it's very helpful to say, as Lord Justice Murray said in Coker, another church case, that a priest is not employed because their appointment was not accompanied by an intention to create legal relations. That, together with the proposition that the priest is the servant of God, gives the impression that she operates entirely outside the legal system, looking to God to provide for her. It's not surprising that the Appellant's Counsel pointed to the prosaic documents issued by the Board of National Mission: the advertisement, the written terms and conditions, the letter of offer and formal acceptance. In the face of these documents, how can it be said that there was no intention to create legal relations? That submission seems to me unanswerable. There was plainly an intention to create legal relations, but those legal relations were not a contract of employment. They were an appointment to a well-recognised office imposing legal duties and conferring legal rights. nature of the office inevitably meant that the procedures for appointment will closely resemble those attending the engagement of an employee. No doubt similar documents could be found concerning the appointment of, among others, judges, rent officers and superintendent registrars of births, deaths and marriages. But that does not mean that their appointment to these offices created contractual relations. So it seems that he wasn't going so far as to say there's no legal relationship, simply that there wasn't an intention to create a contractual legal relationship. But that was not a view that prevailed for the rest of the House, of the Committee of the House. We've cited it out of fairness. It certainly seems, in our submission, that Lord Hoffman would have accepted that even though there wasn't a contract of employment, there's something equivalent to an employment relationship for a judge in that passage. Certainly a legal relationship, certainly, if not a contract of employment, close to it. Now, that's the highest this case goes against me. In the rest of it, the analysis is that there was a relationship which was a contractual relationship on the broader definition that we've seen in the regulations, and that's the definition that is used in the discrimination legislation. If your lordships turn for a moment to paragraph 140 on page 172, we just remind ourselves of the nature of that definition. I think it's also in Lord Nichols and Lord Hope's judgment too. It's 140, and Baroness Hale states, the principal question before us is whether the arrangements made between the appellant and the relevant authorities in the Church constitute employment within the meaning of Section 82 of the Sex Discrimination Act. Employment means employment under a contract of service or a contract personally to execute any work or labour. That's the extended definition in the Discrimination Act that was being applied in this case. My lords, what we get out of it, therefore, are really two things. The mere fact that one is holding an office is the beginning, not the end of the question, whether there is an employment relationship or a contract of employment. And that, secondly, it's necessary to look at the terms of the appointment to see whether there's a contract of employment. Thirdly, Lord Scott and Baroness Hale positively contemplated that a judge could be an employee. And we see that in the passage set out in our case. Fourthly, there's nothing in the judgments of Lord Nichols and Lord Hope to contradict that proposition. No reservation was entered on that point, although it wasn't necessary, obviously, for them to address the question of the position of judges. It seems fairly likely, though, that it must have been part of the debate before the Committee of the House. My lords, I'd take you through the judgments then pretty quickly. Lord Nichols' judgment is at page 136. First, the questions are posed in paragraph 1. He puts quotes round employment to indicate the extended notion of employment in section 82. Then he looks at paragraph 7 under the cross-heading Contracts of Service and Clergy and addresses the control questions in other litigation that had taken place before. And one can see some of the discussion in paragraphs 8 onwards. And then he looks at the question of contract for services, the extended definition. This will be apparent from this brief summary. This is 12. There are several different strands in the reasoning of these leading authorities. Some of them call for comment before turning to the facts of the incident case. It should be noted at the outset, in each of these cases, the issue is whether a contract of service existed. In particular, in the unfair dismissal cases, a statutory prerequisite is that the claimant is an employee. An employee is an individual who has entered into or works under a contract of employment, see section 230 that I showed you this morning. That is not the issue in the present case. Miss Percy's claim is based on sex discrimination. The statutory prerequisite for a sex discrimination claim is expressed in wider terms, and then you get the wider definition. G, that is why she didn't pursue her claim for wrongful dismissal by way of appeal from an adverse decision. Her case is she was employed under a contract personally to execute certain work, that is a contract for services, as distinct from a contract of service.
So we're looking, if we go back to Lady Hale's quotation at paragraph 140, we're looking for the phrase, a contract personally to execute work or labour, really, that's what it comes
That's
to.
right. So that's when one uses employment with quotes around it, that's the wider concept of employment. And one pauses for a moment to just reflect for a second why we have this difference in treatment. And it is all rooted in the ancient law of master and servant. Historically, when I started in practice at the bar, in Halsbury's laws, I don't think there was an employment section. There was a master and servant section. Now, of course, there's an employment section. And it goes back to the 19th century law that servants were dismissible at will, or alternatively would have fixed-term contracts, such as sailors for the duration of a voyage or for a particular piece of work.
Well, they're usually dismissible on a period of notice, but that's all they were entitled to.
That was the improvement in the first half of the 20th century. In the 19th century, they were frequently dismissible at will as servants. And that's why office holders became so important, because if you held an office, you couldn't be dismissible at will. You held the office. And so, for instance, as we shall see in a moment, it was a means for securing independence of judges, for instance, and indeed independence for other office holders, that they could not be dismissed at will. Of course, all that changed essentially with first the extension of the period of notice under the Contracts of Employment Act, originally of 1968, and then 1972, and then in 1971 the introduction of the right not to be unfairly dismissed. And then we've built on that with various other aspects of the status of employment through the equality laws as well. So, as is explained later on in Baroness Hale's judgment, the importance of being an office holder changed radically as the status of employment increased in the second half of the 20th century. But this wider construction, a contract personally to execute any work or labour, contemplates essentially a working relationship, not necessarily one which is as subordinate as a contract of service in the old master and service sense. But it's a modern, realistic concept of the relationship between an employer and, in many cases, but perhaps not all, an employee. The personal obligation to work given to a counterparty to the contract. So we then see Lord Nichols looking at office holders and employees. And at this point, he doesn't draw any particular distinction between the two classes of contract of employment and contract to execute, personally to execute any work or labour. He's drawing the distinction between office holders and employees in this wider sense. He says the distinction in paragraph 15 is well established in English law, goes back to old favourites like Ridge and Baldwin and Mallock and Aberdeen, which go to the point about the right to be heard and so on before dismissal. Then the Industrial Relations Act. And he notes in between D and E, since the fundamental change of the law brought about by the Industrial Relations Act, which created unfair dismissal, the problem has arisen, which previously was not of much importance, of defining the circumstances in which an office holder may be said to be employed. Previously, it was a case of defendants seeking to deny an office holder a right of complaint on the ground that he was party to a pure contract of service. Now it's a question of defendants seeking to deny employees the right not to be unfairly dismissed on the ground that in reality they're not employees but pure office holders. So the purpose for which the distinction is relevant has changed. It's a further complication. The distinction between holding an office and being an employer suffered from the major weaknesses that the concept of an office is of uncertain value, ambit. And then there's a discussion in relation to that and the tax position. And then over the page, the question, having looked at all of that, at the top of the page between A and B, in the present case, the nature of the issue is quite different. The question is not whether Miss Percy held an office. The issue is whether she had entered into a contract under which she agreed to provide defined services. Holding an office and the existence of the contract to provide services are not necessarily mutually exclusive. Consideration of Miles and Wakefield in the next two paragraphs. And then a discussion at 23 on the intention to create legal relations.
Well, in paragraph 20, he says, he's so clear. He says, a person may hold an office on the terms of and pursuant to a contract of employment.
Yeah, absolutely.
There's nothing in having an office which necessarily prevents you falling within the definition.
One can almost hear him articulating what Lord Clark said about Lord Oliver's statement in relation to Miles and Wakefield. It was pretty obvious that there was, in fact, a contract. And here, as my lady says, effectively expostulating on that point, that the whole argument that you're an office holder and not an employee is simply an irrelevancy. It just doesn't go the distance. So the next tack that was advanced by the Church of Scotland was the intention to create legal relations point, which becomes 23.
Is this case reported in any place which also reports the argument?
Unfortunately, the Scottish reports don't. I don't know if it is.
Sorry?
It's on page 32, authorities.
32?
Oh, I'm grateful it's in the appeal cases. Yes, it is.
Oh, is it? Oh,
I'm sorry, yes. If you turn on
so
quite
it
a
is.
lot of pages,
yes.
the
Yes.
arguments are...
Oh, thank you very much.
Yeah.
Yes, I thought it was confined to ICR, but that's very helpful.
I think this was one of those
I've looked at it.
Yes.
cases where we perhaps, or my friend had the same thought.
Thank you very
My
much.
lady, was there one point you wanted to go to in the argument?
Well, the only point that is not in my memory, and Lord Hope and I both remember this case very well, is that I'm not sure that this point about office holders had the same prominence in counsel's argument as it, I mean, it is, I do notice that it is referred to, as it had, because, of course, that was the point on which their lordships disagreed.
Yes.
So I'm not sure that it
Yes.
was given the prominence in the arguments. My recollection is that the arguments were a lot concerned with the status of the Church of Scotland and a lot concerned with the status of European law,
Yes.
on which Mr. Napier was
He
involved.
developed submissions.
Yes.
Well, he did, if you look at page 32G, there was a passing
Yes, I can
reference
see that. I can see
to
that,
it, but I
yes.
mean, I think
Yes.
that's about as much as it came to in the argument.
Well, but Mr. Napier was, of course, following on Susan O'Brien.
Yes.
And I think she certainly said, look, it's perfectly obvious this falls within section 82 if you start at 30G. Perhaps what we need to look at is the counter-argument, which is unfortunately very shortly recorded, the argument of Laura Dunlop at 33.
But I don't think that the Church concentrated very much on this office-holding point at
Well,
all.
I'm not sure exactly what follows from that, except to say that I'm very reassured.
Probably thought it'd be pretty hopeless.
Well, I mean, there is a bit at letter H on 33, which I think was part of her point. It wasn't so much an office holder, it's just the duties of a minister of religion, however one describes
Yes.
it, are inconsistent with an intention to create contractual relations, which didn't really work at all, I don't think.
I mean, there certainly has been a line of authority which is actually explored to some extent in your lordship's judgments, that if there was a spiritual relationship, because it was a spiritual job, that that didn't involve a contractual relationship, didn't involve an intention to create legal relations. And the fact that it was an office, I suppose, may have been another way of expressing that point.
So have we got to this, that the fact that you have an office holder the fact that the claimant is an office holder doesn't mean that he or she may not be entitled under a contract of service or indeed services, and in either of those latter cases that would be a form of employment or in a narrower or broader sense. There we have the principle. The question is how you apply it to the facts of this case.
I get one more thing out of this, which is that, that exploring the nature of the content of the contract, actually what is to be done, is certainly important because it was part of what was explored in the second part of this case, because of the Church of Scotland Act argument being a spiritual debate. But certainly, my Lady Hale and Lord Scott saw that as being no problem in asserting that there was a contract equivalent to a contract of employment. And Baroness Hale, in the passage in our skeleton, considered that this was applicable in relation to the judiciary as well. And that's the passage that we found on, inevitably, although it wasn't necessary for the conclusion in...
but for the purposes of your case, does it make any difference whether it's a contract of service or a contract of services?
None at all. None at all, because of the extended definition, which has to be in play here. What we simply say here is, this is about work. It's not about control in the sense of a master controlling a servant, and therefore a contract of service. It's about work in the broad sense, which includes both the two definitions. So that really is where it gets on that. The passage that is found in, and I mean no disrespect to Lord Hope's judgment, which I think is the longest, and he will recall it. But for instance...
It's more about the church than...
Well, I was going to simply say much of it is dealt with the second point, because your Lordship's judgment on the second point was very important. But it's worth looking at page 158, where my Lord Hope set out the terms of appointment.
Page what?
158 in the ICR judgment.
Can we not stick to
Can you
appeal,
give us
please?
the paragraph?
Paragraph
numbers?
97.
Yeah.
I'm sorry, I've marked up the first one, but I'll do the cross-referencing. 97.
As long as we know the paragraph numbers,
No.
it's all right.
And you'll see, what I was going to say is I mean no respect to Lord Hope by not having set out all his judgment in our case. but there are some interesting points in it too, important, helpful ones. In 97, the analysis of the terms and conditions of appointment that Lord Hope carried out is remarkably similar in terms of analysis to that which I did this morning. Salary, supervision, aims and duties, pulpit supply, and payments, and so on. And then, really, I think that's probably
It's
all
really
I need to
paragraph
say.
114. I think I just sort of tried to draw it together.
Yes. I've marked up 112 on to 114. At the foot of 112, just before 113, looking for the moment only at the agreement, seems to me it has all the ingredients that would be needed for it to be treated by the courts as intended to create legal obligations and a legal remedy. Then there's the question whether the position which the appellant was to enjoy was employment, different question. We're looking to see whether there was a contract of service here, but whether it's a contract under which the appellant undertook personally to execute labour, work or labour, personal obligation to execute work or labour, and then 114, you apply the Mirror Group and Gunning's line of authority.
So is it said that there's no contract here?
It was said that...
No, in our case?
Yeah, in this case, yes, absolutely.
No contract?
It's asserted simply by the respondents that there was an office, and that's it. That is the assertion.
And that was accepted by the Court of Appeal.
That was accepted by the Court of Appeal.
Did they consider this analysis, the Court of Appeal?
Well, yes, or at least it was, Percy was cited to them at length, but is not cited at all in their judgment. Now, I want to immediately say that was a cause of some frustration to us, and it formed a major part of our petition. What can be said is that the Court of Appeal, like you, had 2 days at this, And a good deal of the time was spent on the question of just and equitable and whether the claim was in time. So the amount of judicial thinking was much more limited on these issues.
It's just worth noting, Mr. Allen, it's relevant to what we looked at this morning. If you look at my paragraph 96, you can see how her appointment came about. I mean, she responded to an advertisement. There was a discussion on the telephone. There was an invitation. There was a letter confirming the invitation, enclosing a copy of the terms and conditions, which I quote, and that was it.
Yes.
And the real punch of the argument for her was to be found in the terms and conditions,
Yes.
and the fact that provided she fulfilled these things, she got some money, she got paid, and was obviously providing services in the provision of religious services and so on and so forth in the parish.
And that's why I showed you this morning how it was that Mr. O'Brien was appointed, how the terms and conditions are set out in the contract, how his agreement to those terms and conditions was a condition for the recommendation for his appointment, and how on the renewal the Lord Chancellor required him, on each occasion on the renewal, to signify his express agreement to those terms and conditions before the renewal took place. And the terms and conditions themselves are similar analytically to those which one finds in this class of case, and indeed any contract of employment. Bluntly, once analysed like that, we say that the law could not possibly, on the one hand, describe this as a contract of employment, per se, and go so far as to say that the relationship between a recorder and the state isn't even an employment relation. We say it's a contract of employment, but at the very least it's an employment relationship, even if you go with Lord Hoffman and say that there was no intention to create contractual relations.
Do we want to take more time on Percy, or
Well,
I think you'd like to show us...
I've set out in extenso, and I hope that you will have read
yes.
Baroness Hale's passage.
Yes.
And I've given you the reference to Lord Scott, which is a very short judgment. Would you
how does the analysis in Percy fit with the Court of Appeal's statement of paragraph 47 of the judgment, which says there's copious authority to support the proposition that a statutory office holder, such as a judge, is not employed under a contract?
Well, the short answer is that the three cases cited simply don't go that distance and are not susceptible to this kind of analysis. And that's going to be the next stage in the argument. The key case is Terrell, I think, if I remember rightly, in the passage of the judgment. I haven't got it open in front of me.
For example,
Yes,
Terrell.
For example, Terrell. And I will take you there. I have shown you Baroness Hale, paragraph 87. Can I move in my case directly to the points that my Lord has asked in our case at 28? We cite in paragraph 89 the passages in the Court of Appeal's judgment, and we say that the Court of Appeal simply accepted that submission from Mr. Kavanagh without thinking about Percy, and equally without any analysis of actually what they amounted to. So if let's go to Terrell, which is at 2 tab 35.
Remind me, did they refer to Percival Price?
Yes.
They did in the archaeology, but no further. And the argument in relation to Percival Price, which I have to deal with shortly, is to say that was a decision in relation to Article 119, and Article 119 was different from part-time workers. That's the argument. As I shall show you, that argument goes nowhere in the most recent authority of the Court of Justice.
You refer to in paragraph 43.
That's right. So, if I can take you to Terrell.
That's as far as it goes.
This case is a judgment, as first instance, in front of Lord Goddard, sitting as Chief Justice in the QBD.
Sorry, what was the reference?
Terrell, it's at tab 35 in bundle 2.
Thank you.
It concerned the premature retirement of a judge of the Straits Settlement who had the misfortune to have lost his terms of appointment during the war. That's to say, his letter of appointment during the war. And if one just looks at the headnote for a moment, claimant was off in his 49th year, was offered an appointment as a Queenie judge. The letter written on behalf of the Secretary of State, the claimant was informed the qualifying term for pension was 7 years, compulsory retiring age in the case of a judge was 62. 42, well, the claimant was on leave in Australia, Malaya was occupied, letters patent disappeared. On the 7th of April, 42, the claimant was informed that the Secretary of State could no longer justify retaining him now that his post was necessary in abeyance, and that there was no alternative but to award him a pension on abolition of office. The claimant's appointment accordingly ended long before he was 62, sorry. On the question whether the claimant was liable in law to be required to retire before reaching the age of 62, it was contended that the principle of judicial independence in the Act of Settlement was to be regarded as part of the law in the Straits Settlement. Therefore, the claimant held office during good behaviour and could not be removed. Alternatively, that if it had been appointed during pleasure, the correspondence between the claimant and the Secretary of State constituted a contract enforceable against the Crown, and that the Crown would employ him until he attained the age of 62. So he's asserting that the letter of appointment saying he'd retire at 62 gave him a contractual right to go on to that age. And the headnote really summarises the point, although I'll show you a couple of passages in a moment. Provisions of Section 3 of the Act of Settlement relating to the tenure of offices of judges of the Supreme Court in England didn't apply to the Straits Settlements.
Well, that was the main reason for the American colonies' dissatisfaction. Ultimately led to certain events at the end of the 18th century. Yeah.
Nothing changes sometimes, one thinks. Fortunately, in the field of employment law, it does, but it was for the Crown, by exercise of the prerogative, or Parliament by statute, to set up courts. The conditions under which judges of those courts held office depended upon the terms on which the Crown or Parliament established them. It was clear from a consideration of the Act and the Royal Letters Patent of 1911, which instructed the Governor that he might appoint judges to hold office during His Majesty's pleasure and the royal warrants, that judges held office during the royal pleasure. Accordingly, the claimant, having been appointed by letters patent, issued pursuant to a royal warrant, which followed the terms of the letters patent of 1911, held office during the royal pleasure. In short, there was nothing for a contract to bite on, it was being said. That it was a rule of law that once it was established that the Crown had the right to dismiss at pleasure, that right could not be taken away by any contractual arrangement made by an executive officer or Department of State. Judge appointed during the pleasure was in no different position from the point of view of dismissal from that of any other person in the service of the Crown. Having been appointed to hold office during pleasure, no correspondence which took place before or after the claimant's appointment could affect the terms of appointment. Accordingly, the termination of the appointment by the Crown was justifiable in law. So one could see immediately that it simply isn't this case. Here, there was a pure act of prerogative, appointment under the prerogative powers that were conferred upon the Governor to appoint judges on pleasure. The difference here is that the appointment is under the Courts Act, and the Courts Act makes it absolutely clear that you're not appointed on pleasure, you're appointed on terms in relation to capacity and misbehaviour, and terms and conditions, and those terms and conditions are developed and established and require individual specific agreement in the iterations of the reappointments under the different contracts, different versions of the contract, the Courts Act 1971. So you simply cannot say that Mr. O'Brien served during Her Majesty's pleasure in the way that Mr. Terrell did.
So the first sentence of the Court of Appeal's judgment, where they cite this as authority for the proposition, misunderstands you say the point at issue in Terrell.
Just the case simply doesn't go the distance for which it is said to go. And that really is it, as far as Terrell is concerned. One gets nothing more out of it. My friend cites one short passage, I think right at the end of the judgment. If he can remind me the passage. Thank you. He says, without reasoning, in the middle of 499, apart from this, I agree with the arbitrator that a judge holds office by royal appointment and not by contract. I think that the correspondence referred to does no more than inform the claimant of the general conditions applicable to the office. It tells him that at the age of 62 he will have to retire and might expect to receive a pension. It does not amount to an agreement that he is to be appointed for a definite period and not at the pleasure of the Crown. Now, I pause there for a second. That may well have been true in Mr. Terrell's case, but we say that the proper approach for this court is to analyse the documents I took you through this morning, and we simply say that here we have the benefit of the documents, Mr. Terrell didn't. We can show in terms the requirement of acceptance of offered terms and conditions as a precondition for either appointment or renewal of appointment on each successive occasion. And one simply cannot, applying the kind of approach that Lord Justice Mance took in Baird and Marks and Spencer, say that there is no contract here. So, with all due respect, Terrell is of no assistance to the issues in this case at all. I told the court that I would show one case in which Lord Diplock had no difficulty in saying that a judge could sue. If you turn to my case, our case, under the heading Terrell, paragraph 93, these points I've just made are set out. And in 97, we said that Terrell had been cited in a number of cases, but not, it should be added, not particularly relied on in the judgments. But there is a Privy Council case which may be of some interest, which is Codus Farren at 463, bundle 4, tab 63. Just open for a moment. Terrell put us on inquiry in relation to this case. The appellant, a civil servant, sued the respondent as representing the Crown for the balance of salary due to him as an increment denied to him by the government because he didn't pass a test in the Sinhala language as required by the Treasury Circular. The suit raised constitutional issues on the validity of the Official Language Act in Ceylon and the Treasury Circular. The present appeal dealt only with the preliminary issue whether a civil servant had a right of action against the Crown for salary due in respect of services which he'd rendered. Now, it is only a civil servant's case, it's not a judge case, but it's clear that the Attorney General from Ceylon advanced Terrell. If you go to page 112, you can see it's the last of the cases cited in argument. And it was held that under the common law of Ceylon, an action did lie at the suit of the civil servant for remuneration agreed to be paid to him by the terms of his appointment and remaining unpaid as arrears of salary, which accrued during the currency of his employment. And one can see Lord Diplock, I think, giving the opinion of the committee at page 1117 at H. Even if the relationship between the government of the United Provinces and its civil servants in Ceylon had formally possessed the legal characteristics of contract of service, and they'd been entitled to sue, that government didn't follow that a corresponding contractual relationship and right of suit between the Crown and its civil service in Ceylon was created by proclamation. And he then goes through the question as to whether that former right was incompatible, concludes that there was no incompatibility, and at the end of that page concluded that there was nothing inconsistent with British constitutional theory in the Governor of Impon being empowered by the proclamation to enter into a contract on behalf of the Crown of the person, and he goes on to say to be able to sue for it. And one can see the last bit of that on page 1123. I don't waste any more time on that, but that's just one example of saying that the fact that you're in Crown service isn't in any sense inconsistent with being able to sue for the remedy that you ought to have for the non-payment of wages. In our case, we go on to show how the old law saying that civil servants didn't have contractual rights disappeared in the 1990s. That's paragraph 99 in McLaren and the Home Office. For your marginal notes, that's tab 18 in bundle 1. And the passage from Lord Justice Wolfe is set out in the box, citing Codeshwaran, and that's been followed later in Ex parte Nangle in 102. That was an executive grade civil servant in the Lord Chancellor's Department, sought to judicially review the government who attempted to transfer him to another department. The High Court made clear that such relationships can be regarded as contractual, and the mere fact that you were in civil service and appointed to an office in the civil service didn't mean you couldn't have contractual rights. So I don't think I need to develop those any further. So in 103, on page 32, we say Tyrrell is confined to the issue of the Crown having the power to dismiss at will, a situation irrelevant to a dispute over less favourable treatment with reference to no pension. The term holding office by pleasure does not prevent contractual rights arising, whereas for all judges now, there cannot be dismissal at will. It's rather convoluted, that last sentence. I think I should put it simply this, that you could not now say that a judge simply holds office by pleasure. That would be a neater way of putting it. The next two cases that the Court of Appeal looked at were Knight and Sheikh, and I'll take those fairly quickly. Knight is in bundle 1 at 14. It's a rather different set of facts because it was a lay justice that was in issue. Head note, it's a judgment of Mr. Justice Slynn, as he then was, in the Employment Appeal Tribunal, back in 1978. A woman, Mrs. Knight, wished to become a Justice of the Peace, was interviewed by a committee established to advise the Lord Chancellor on the appointment of justices. Not recommended, presented a claim to an industrial tribunal against the Lord Chancellor and the attorney, claiming the questions put to her during the interview amounted to unlawful discrimination on grounds of sex within the meaning of Section 6. The IT found that they had no jurisdiction to hear the complaint under Part 2 of the Act, since the position of Justice of the Peace was not, quotes, employment by the Crown within the meaning of our old friend, Section 82. And that a Justice of the Peace, as a holder of a statutory office, was expressly excluded from the provisions of the Act by Section 85. Applicant appealed, and it was agreed between the parties that the Lord Chancellor ought not to be a respondent to the appeal, since the Lord Chancellor was not an authorised department for the purposes of the Crown Proceedings Act. The appeal was dismissed, but since the Justice of the Peace was not paid a salary and was not subject to direction as to the matter in which he fulfilled his obligations, not employed under a contract of service or apprenticeship. Since he didn't make a contract with the Crown to execute personally any work or labour, appointed to hold the office, there could be no breach of Section 6. And then, secondly, that there was no service in relation to the advisory committee for the purposes of Section 85, subsection 2. And then the second part of the second holding, that similarly, service in Section 85, 2b referred to the service of a Justice of the Peace to the Crown itself, and not service for purposes of a person holding a statutory office or for the purposes of a statutory body. Well, there are some obvious points of difference between that case and this. There's a problem about who the respondent to the action was. After all, she was suing not the Lord Chancellor, but the Attorney General as the default respondent for the Crown. But essentially, the complaint was about the panel, the Justices of the Peace panel, that had failed to recommend her. And it's fairly obvious that she was never going to have been in any kind of a service relationship with the Justices of the Peace panel. So that does make one point of distinction. Not only that, but also, of course, she wasn't paid. It was a voluntary position.
Yes, would it have made any difference to the reasoning on page 199 if she had been a stipendiary magistrate?
Well, it's just about possible. If we go on to 201G, we can see this. Mr. Birtles relies upon 85.2b. He says once again the service which is referred to as the service of the advisory committee. It's for the purposes of the person holding a statutory office, again, the committee advising Lord Chancellor. It really, essentially, Mr. Justice Lynn was saying, it seems to us here that the service which is referred to is the service of the Justice of the Peace or the candidate for appointment, which is for the Crown itself, and that there's no service which is for the purposes of a person holding a statutory office or for the purposes of a statutory body. He doesn't address the specifics as to whether there was paid employment in this case, so it was argued in a rather different way. But he did recognise that there might possibly be a contractual, a collateral contract. If your lordships go to 198, and there's a passage which starts between E and F, which I invite you to just read, and then at H, Mr. Glick, for the attorney, referred to IRC and Hambrook. Lord Chief Justice, at first instance, reviews the authorities, the nature of the relationship between the Crown and its officers, contrasts them with the ordinary relationship of master and servant. Lord Goddard cites a number of cases in which this matter has been discussed, but he states his view. Established civil servant is appointed to an office, is a public officer, remunerated by monies provided by Parliament. His employment depends not on a contract with the Crown, but appointment by the Crown, though there may be, as indicated in Riley's case, exceptional cases, as, for instance, an engagement for a definite period where there is a contractual element in or collateral to his employment. So it's an early case, 1978. It's recognised at that stage there could be collateral contracts together with service as a Crown servant, but that part of the argument doesn't go the distance in the position of a lay JP. And then the next case that's referred to is Sheikh, which is in Bundle 2 at tab 33. And we've summarised this in our case, and although it would be helpful to have the judgment open, I think we can deal with this fairly swiftly by reference to what we've said in the printed case. Paragraph 108. Volume 2, tab 33. Sheikh concerned complaints by a wing member of the Social Security Tribunal of race discrimination. They sought to establish their employees. Findings of the Employment Appeal Tribunal as to the terms of the wing members' appointments were materially different from those in question here. And if the court will turn up paragraph 31 sub 1, which you will find on page 12 of the judgment, find well-recognised indicia of a contract of service, quite satisfied that there's no contract, no sufficiency of control or direction by the respondent over these judicial officers did their work. Indeed, the contrary would be inconsistent with their judicial independence. No mutuality of obligation, one of the irreducible minima of a contract of service. In short, there was no obligation on a wing member in the Social Security Tribunal to turn up and do the job. They could do it if they wished to, but not otherwise. Specifically, the respondents were under no obligation to provide sittings for the applicants during the term of their appointment. Further, no one respondent had the power to appoint and to dismiss, province of the Lord Chancellor, and to allocate cases to him, function of the third respondent. Finally, on balance, we're not persuaded that sufficient aspects of an employment contract were present, including contractual, that is, non-statutory sick pay, pension rights, or holiday pay. In these circumstances, we do not consider the extended definition, which is exactly the same as in the Sex Discrimination Act, nor the more limited definition in Section 230 assists the applicant. Well, one can see immediately the distinctions on the facts between this case, Sheikh, and our case in front of your lordships, where plainly the aspects which were found to be missing, the mutual obligations to provide work, the obligations to pay, the obligations in relation to statutory sick pay, holiday pay, and so on, are explicit. So we say Sheikh does not assist at all. The most that can be said is that one part of the reasoning of the court was that there was an inconsistency between the doctrine of control and judicial independence. And your lordships have already had our short submissions in relation to that that certainly is not consistent with the extended definition, and in any event is well covered by many other circumstances in which there are recognised contracts of employment where employees are positively employed to act independently. So those are the propositions, but it's interesting to note also in paragraph 112 of our case that the AT considered that the position might well have been different under the Race Relations Act had it been amended to take account of the broader provisions of Directive 2000/43. For your marginal notes, that is volume 6 at tab 123. It's actually marked, I think, as 23 in volume 6. And that point is picked up at 31 sub 3 in the paragraph 113 over the page. Yeah, I don't need to go to that. So on this part of the case, our submissions amount to this, that there's nothing in the respondent's point that a judicial office is significantly different from other kinds of work. There was offer and acceptance. The domestic bifurcation into office holders who don't have contracts of employment and those that do is anachronistic, at least in the context of this case. That's not to say there may not be office holders who have no contracts of employment, but it simply goes nowhere to say that you've got an office. And whether or not your lordships hold that there was a contractual relationship, the obligations are mutual and very closely analogous to a contract of service, albeit here all that needs to be proved is that there was an obligation personally to do work and labour. And we add, of course, that there was no consideration in the Court of Appeal's judgment of whether there was an employment relationship, even though they held that there was no contract of employment.
Yes.
Now that takes us to part 3 of the case, which concerns the scope of the directive. And I was dreading dealing with this at 3:30 because this is, I'm afraid, difficult stuff, 3:15, because it's difficult stuff. As the court will know frequently, the obligation to give a teleological interpretation, a purposive interpretation of a directive, can be quite tricky. It involves looking widely at the context within which legislation is made. Now, we start in our case by reference to Clause 2, and I don't need to take that through with you. I've made the point that Clause 2.2 shows a controlled method of derogation from the scope of the clause. In 124, paragraph 124, we say that it must be construed in a European context. And it is our submission that the case law shows that the protections intended to be provided by the directive are wide and that arbitrary distinctions should not be made. Moreover, it's submitted that the mere classification in domestic law of what is clearly a work relationship as being other than employment is neither here nor there. This is so particularly where that relationship involves work for remuneration on defined terms. It's submitted that the domestic classification of judges as office holders conceals rather than reveals the true nature of the relationship for the purposes of the directive, which, once examined, is obviously within the intended scope of the PWD. Now, there's a short point that I make at the beginning. On one reading of the text of Clause 2.1, it ought to enable a member state to decide whether the PTWD applied or not. It could, a state on one reading, simply say, nothing that happens in Ruritania is employment. We don't call it employment in Ruritania. Our law, our collective agreements, our practice simply don't speak of employment contracts or employment relationships. Ergo, the PTWD does not touch us at all. It's patently obvious that that would not be permissible in the field of social law, where the European Union is legislating, the European legislator wishes to secure minimum standards for purposes of the social aims of the European Union. So there has to be some different construction from Section 1, which, on the hypothesis I've just given, would give an unlimited discretion.
You said Section 1.
Clause 2, sub 1.
Right.
The case advanced for the respondent is that they have a wide discretion under Clause 2.1, and it was a minor exercise of that discretion in Regulation 17 to cut out the application of the regulations to fee-paid judges, judicial office holders. In fact, they go further than that because they also argue that no judges are touched by the part-time workers regulations. So, for instance, they also argue that part-time salaried judges would not be able to complain under the regulations by comparison with the treatment of full-time salaried judges. They say the regulation just does not touch judicial office holders at all. But their argument is that that's a minor cutting out or cutting down of the scope of the directive in the domestic implementation of its provisions.
You are now looking at the directive. I noticed that when we were being introduced to this morning, you didn't look at the preamble.
I have to do that, and that's where I'm going to,
you are going to
come to.
Right.
And what we do is to look at that in 129.
Yes.
What I propose to do is to look at it by the most recent case given by the Court of Justice last week.
Right.
So I will do that now and go straight to...
I don't want to take you out of order. It's obviously an important point that's got to be dealt with.
Absolutely. But I want to the court is probably entirely clear about the difference between the two sides. The width of discretion claimed by the state, whereas we say that that approach wholly undermines what the directive was about.
So how do you define the width of it?
We say that, in fact, that whereas the member state can define what are collective agreements or practice or law, the question of whether it's classified as an employment contract or an employment relation is a matter of European law. And we will make good that point by reference to the purposes of the directive explained by the Court of Justice, which shows, and I shall show you this in a moment, that an approach to worker, because after all it's protection of workers, in the part-time workers directive is to be similar to that under Article 119, and by an explicit rejection of the argument that is advanced by the state.
And which paragraph of the Court of Appeal judgment do they focus on these issues?
55?
The argument below went in a number of different ways. We had to accept, because at that stage we didn't have Cerro Alonso in front of the Court of Appeal, which I shall show you here.
So was this point taken at all in the Court of Appeal?
Well, it was taken to this extent. We put it in a different way. we said that there was a very limited discretion by clause 2.1 and that to exclude judges was inconsistent with it. But the law, we didn't cite Cerro Alonso, which I'm afraid was my fault. I should have cited it, but the case came on very quickly and I wasn't aware of this aspect of it, and I'll show you that. And we couldn't have cited Bruno and Pettini. That judgment was only given last week, nor could we have cited Impact.
So I think they do, I mean, they barely touch on it, but it's paragraph 55, isn't it? At the very end.
The closest you get to it.
For the reasons given by Mr. Justice Lighting Christie, it was well within the discretion to exclude part-time judges.
That's right.
I think that's the beginning and the end of it, isn't it?
It is indeed. And the argument...
So we have to look at Mr. Justice Elias.
We do, and that's in Christie, and I'll take you to that shortly. But the argument that was accepted by Mr. Justice Elias and Christie was that, and this is the argument that was put forward, was that Advocate General Cockcock, in a case called Whipple against Peake, too many vowels, too many consonants, in a case called Whipple against Peake, essentially said that member states had a full discretion to decide who would be within the scope of the directive.
I have the impression, I'm sorry to keep coming back to this, but the paragraph 16 of the preamble had a bearing on both Justice Elias and the Court of Appeal. They quoted in terms.
Yes. And this is the difficult bit about the scope of the directive, because 16 seems to suggest that there is such a discretion. I'm proposing, I think, first to simply show you the passage in Whipple and Peake in the Advocate General's opinion, and to do that through showing you Christie, to show how the Court of Appeal reached their judgment, so that we can then see the European law as it now is in context. We dig out Christie, first of all. It's tab 5 in volume 1. Mr. Christie was a Social Security Appeal Tribunal chairman. He claimed that he was a worker within the regulations. And ET decided on a preliminary issue of law that the holder of a judicial office remunerated on a daily fee-paid basis, the claimant was excluded from the regulations by virtue of Regulation 17. On appeal by the claimant, dismissing the appeal, that there was no concept of worker which had to be applied to all cases where it arose in the context of community law, and both recital 16 of the directive and clause 2 of the framework agreement annexed to it envisaged that the meaning to be given to an employment relationship would be left to each member state, that the discretion accordingly conferred on the UK by the directive, while necessarily involving some limitation, afforded a reasonable leeway in defining who was a worker, and a minor limitation such as the exclusion of a certain limited category of part-time judicial officers by Regulation 17 was consistent with that direction. So that repeats very much what I've just said to you as the effect of it. The reasoning behind that lies in the citation from Whipple and Peake. And the judgment, if you can see the arguments in outline at paragraph 16, you see our old friends Terrell and Knight and Shake. And then the argument was advanced by Mr. Shake was that there was a common concept of a worker for the purposes of European law. Then the ET judgment is set out, the issues at 24, and the heading, is there a European community law concept? Reference to Percival Price and to Laurie Bloom. And then the reference to Whipple and Peake is at 30. Mr. Kavanagh submits that this argument is misconceived. He rightly observes that the passage in Percival Price, paragraph 26, Sir Robert Carswell agreed with counsel that the term of worker is capable of bearing a different meaning in different parts of the treaty and in other community legislation. More specifically, he relies on an observation of the Advocate General in Whipple and Peake case concerned both the application of the Sex Discrimination Directive and the Part-Time Workers Framework Directive. And Mrs. Advocate General Cockott said, by question 1AC, the referring court essentially wishes to establish whether the concept of a worker within the meaning of Article 141, Directive 75117, that's Equal Pay Directive, Framework Agreement on Part-Time Work, and the Community Charter of Fundamental Social Rights also encompasses persons who are employed only to a limited extent and carry out their work on demand without fixed working hours having been stipulated in advance. And she held there is no single definition of worker in community law. The meaning of the term depends on the particular provision concerned, citing Martinez-Sala and Allenby. Distinction should therefore be drawn in this respect between the Framework Agreement on Part-Time Work, on the one hand, and Article 141 on the other. I pause there to say I will show you in due course that that distinction is not now drawn by the Court of Justice. The concept of a worker under the Framework Agreement on Part-Time Work, Framework Agreement on Part-Time Work applies according to Clause 2.1, the passage we've seen, and then in 45, consequently, for the purposes of the Framework Agreement, the term worker is not a community law concept. Indeed, the personal scope of application of the Framework Agreement is defined by reference to the national law applicable in each case. The term worker, therefore, has to be defined in reliance on the law, collective agreements, and practices in force in each member state. The member states have wide discretionary powers in this respect. Only the very broadest limits can be determined in this respect by reference to community law. It should therefore constitute a breach of duty of cooperation, Article 10, if a member state were to define the term worker so narrowly under its national law that the Framework Agreement on Part-Time Work were deprived of any validity in practice, and achievement of its purpose, as stipulated in Clause 1, will greatly obstruct it. However, there's no sign of that here. And that, essentially, was the passage which founded the judgment in Mr. Justice Elias's judgment. He said that discretion was wide, and therefore they could cut out through Regulation 17.
He says that that was based upon what the court itself had said.
Yes.
Yes.
But
I
actually,
can see that. I mean, that's
there are a number of things that need to be said in relation to this. The first is, you do not find this discretion stated in the judgment of the court in Whipple and Peake.
Or in any previous case.
No.
So the statement just above the end of the last three lines of paragraph 30 is wrong, is it?
There is nothing to this effect in the case law that was cited by the Advocate General to support this proposition.
She cites the cases for the purpose of saying there isn't a single definition, which is
and-
a different proposition entirely.
Exactly so.
The cases she's referring to are the ones in paragraph 40. Well, the one that Ms. Justice Elias is referring to are the ones in her paragraph 43.
That's right. And we don't quibble with the fact that there is no single definition. What we do say is that this directive is that class of directive in which, notwithstanding what appears to be said in Clause 2.1, because it's concerned with fundamental rights of equal treatment within the social policy of the community, the union, effectively, the member state cannot have any serious discretion to exclude those that are in employment contracts or employment relations. That's the submission that we make. What we will show you at the moment is this, is that a very similar clause in the Working Time Directive was construed in a case called Kiel, as in the state of Kiel, the Kiel Canal, against Jaeger, and the Court of Justice adopted the proposition which I have advanced, i.e. that member states don't have a discretion in the working time context. And we will show you also that the Court of Justice, when having to choose between Advocate General Cockott in Whipple and Peake or adopting the Working Time Directive approach in the Kiel against Jaeger case, chose the Kiel against Jaeger approach.
And is that where we see the last sentence of paragraph 43 is now out of date.
Yes. And that's what I'm going to have to develop to you. Now, it's probably helpful to show you the state of Kiel against Jaeger case next, which is a working time directive case, but you will see the point that we seek to make.
And when was this decided?
The Kiel case was, I'm sorry, I can't remember the date, but I'll tell you in a second. The contrast between the two comes in Cerro Alonso and then in the most recent judgments as well. But let me get Kiel out for you. It's at volume 4, tab 64. The facts were these, that a doctor was, it's an absolutely mundane set of facts which might easily have applied here. A doctor was employed at a hospital in Germany and he had what was called on-call duty, which essentially meant that he had to be and sleep at the hospital even though he wasn't working. And the question was whether or not the period when he wasn't working but had to be at the hospital was working time. What happened was that the German state of Kiel defined it as not being working time, but as rest time, as rest time. And so the question, therefore, before the court was whether Kiel, in taking that approach, had applied the directive properly. Now, in order to understand the issue, it's necessary to look at Article 2, Sub 1 of the directive itself.
Just to get ourselves in order, Kiel came before Whipple.
It did. It did. And, but what we're going to look at in a moment is when these two cases are counterposed.
When they're put together, yes, I see. Yeah.
So if the court will please look at page 1545.
Now, this analysis wasn't put to the Court of Appeal.
No,
in our case.
it wasn't. I confess that that I can be criticised for not having put Cerro Alonso before the court. Neither did my friend, I'm afraid. I can only explain by the fact that there was an expedited appeal and I simply didn't pick it up. But we'll sort of explain that further in a moment. But if you look at Kiel, 1545, Article 1 of Directive 93/104, which is the Working Time Directive, lays down minimum health and safety requirements concerning the organisation of working time and applies to all sectors of activity, both public and private, with the exception of air, rail and so on. Under the heading Definitions, Article 2 of Directive 93/104 provides, for the purposes of this directive, the following definitions shall apply. Working time shall mean any period during which the worker is working at the employer's disposal and carrying out his activity or duties. And then you will see the qualifying phrase, in accordance with national laws and or practice. And so what the state of Kiel said was, we don't treat doctors on call, but not actually working, as being working under our national laws or practice. If you then turn forward, the questions referred at 1552, 43, paragraph 43 onwards. 44, in the light of the matters pointed out in the preceding paragraph, the first two questions, which it's appropriate to examine together, must be understood as essentially asking whether 9304 must be interpreted as meaning that a period of duty spent by a doctor on call, where presence in the hospital is required, must be regarded as constituting in its entirety working time for the purposes of that directive, even though the person concerned is permitted to rest at his place during that period when his services are not required, with the result that that directive precludes a member state's legislation which classifies as a rest period and employs periods of inactivity in the context of such on-call duty. So that frames the question. And what then follows is an exposition of the social context of the legislation. First of all, it should be stated at the outset, it's clear from 118 of the treaty and so on, legal basis of 93-104 and the various recitals, that the purpose of the directive is to lay down minimum requirements intended to improve the living and working conditions of workers. According to those same provisions, such harmonisation at community level in relation to the organisation of working time is intended to guarantee better protection of the safety and health of workers. Then a citation of the Community Charter of the Fundamental Social Rights of Workers in 47. With regard more specifically to the concept of working time for the purposes of the directive, pointed out in CIMAP, Court noted the directive defined that concept as any period and so on, and an exposition of that, and a further discussion of that. And the conclusion, time doesn't permit me to read all of that, is over the page, in 58 and 59, is this. The concepts of working time and rest period within the meaning of 93-104 may not be interpreted in accordance with the requirements of the various legislations of the Member States, but constitute concepts of community law which must be defined in accordance with the objective characteristics by reference to the scheme and purpose of that directive, as the Court did in CIMAP. Only such an autonomous interpretation is capable of securing for that directive full efficacy and uniform application of those concepts in all the Member States. Accordingly, the fact that the definition of the concept of working time refers to national laws and/or practice does not mean that the Member States may unilaterally determine the scope of that concept. Thus, those states may not make subject to any condition the right of employers to have working periods and corresponding rest periods duly taken into account, since that right stems directly from the provisions of the directive. Any other interpretation would frustrate the objective of Directive 93-104 of harmonising the protection of the safety and health of workers. So it leads to what might seem a paradoxical result until you do a purposive analysis of the purpose of the Working Time Directive.
It's not actually, it doesn't strike me as all that paradoxical, actually. I'm sorry, I keep looking back at recital 16, which you still haven't come to, because the proviso to the recital is really making exactly the point you read in paragraph 59. And this is way back in 1997. So I think it's rooted in community law from the start, that in this particular type of thing, it's all very well to have national laws and definitions and so on, but the purpose of the directive is the ultimate guide. Yeah. And that's what I think comes through the proviso.
That's what is saying here. That is absolutely right. And indeed, your Lordship's point to me is I think, picked up, if I remember rightly, in either in one of the cases that I'm coming to. I shall find it for you and show it to you.
Sorry, I'm jumping ahead of you.
That's Keel.
Yes.
And where does this fit in the timescale of the Advocate General's opinion we were looking at a few minutes ago?
In the Cockott
case.
This is before Cockott.
And does she or he consider this analysis in Cockott?
Sure it's before Cockott?
Well, she certainly doesn't adopt that analysis, and nor does the Court, which isn't quite the answer to your Lordship's question. But perhaps we can
tab 87 will tell us, won't it?
To Whipple and Peake next. And Whipple... Whipple is at...
Tab 87.
87, thank you. Now, the facts of Whipple are also extremely important. It's been described by Baroness Hale as being an outrageous claim, and indeed it was. A most unusual claim. Mrs. Whipple had something that would not be described as a contract of employment in the United Kingdom. She had an agreement to work if she wished to, and if she was asked to, with Peake and Kloppenberg. It's what's sometimes called a 0 hours contract. On the other hand, the work that she did was normally done by people working 40 hours a week and 8 hours a day. And she complained under the Part-Time Workers Directive, saying that she was discriminated against because she was not offered work on the same basis. The case was weighed off by the court, essentially, that her employment was simply not comparable to the work of the full-time workers, and one can see the obvious logic of that. Keel is cited in the judgment of the court, and you can see that at 1606 at the top, and indeed in the AG. I've read you the AG's judgment, opinion, in Christie, and the passage is at 1616.
I got a very awkward version of Whipple because all the pages are out of order.
Ah, well, if that's the case, then there is a better version in the Lucy
Yes.
at tab G.
Thank you very much.
We were aware that something might have gone wrong, but
Yes.
it's in the Lucy at tab G.
Oh, yes, it's better.
But this is the same, very same document as we were looking at, quoted by Miss Justice
Elias in Christie.
Yeah.
So we got the Keel judgment in September 2003. She writes in May 2004.
And the judgment itself
Is October.
is 12th of October 2004, 1634. One has to recognise that she made various different claims, not just under the Part-Time Workers Directive, but also under the Equal Pay provisions and the Equal Treatment Directive. And you see that in paragraph 1. Then we get the legislation set out, and I don't need to read all of that to you. I can go straight to the reasoning at paragraph 35. And this is the reasoning of the court. First question, the referring court is asking essentially whether a worker with a contract of employment such as that in the main proceedings, under which hours of work and the organisation of working time are dependent on quantitative requirements in terms of available work, and determined only on a case-by-case basis by agreement between the parties, is within the framework agreement. Then jump to 37, under clause 2.1 of the framework agreement and next to Directive 97/81, that agreement applies to part-time workers who have an employment contract or employment relationship as defined by the law, collective agreement or practice in force. Under clause 3.1, the term part-time worker refers to an employee's normal hours of work calculated on a weekly basis or an average hour over a period of employment of up to 1 year, less than the normal hours of work of a comparable full-time worker. Under clause 2, the derogation provision, as the UK has rightly pointed out, it's for the referring court to make such determinations as may be necessary in order to verify whether that is the situation, the case before it. And then this is the judgment. In the light of the foregoing considerations, the reply to the first question must be that a worker with a contract of employment, such as that in the main proceedings, on which hours of work and the organisation of working time are dependent on the quantity of available work, determined only on a case-by-case basis, comes within the scope of Directive 76/207. Such workers also come within the scope of the framework agreement, where they have 1, a contract of employment or relationship as defined by the law, collective agreement or practices in force, their employees whose normal working hours calculated on a weekly basis on average over an employment period, which may be up to a year, less than those of a comparable full-time worker. And 3, in regard to part-time workers working on a casual basis, the member state has not, pursuant to clause 2.2 of the framework agreement, excluded them wholly or partly from the benefit of the terms of that agreement. Now, I have to say that I find no reasoning in that. It's simply a statement that she is within the scope of the directive in this particular case. So that's it. That is the extent of the judgment in Whipple and Peake. It doesn't adopt the discretionary argument.
It doesn't mention it.
Just simply doesn't mention it
At all.
Full stop.
Well,
Now,
it does in relation to paragraph 2.
It certainly does, yes. And that's the earlier point that I've been making at some length to you. The way we read this case is completely different from the way the respondent reads it. We read it as being an argument that the domestic legislation had actually gone too wide in including within the scope of application in Germany such workers? And the court was essentially saying, no. That's a completely different question as to whether, as in this case, the domestic regulations have gone too narrowly in excluding those who otherwise plainly are doing employment or working in the sense that I've already developed to the court. In short, this case actually shows the width of application of the directive when you read the judgment itself. I totally accept that you can look at the discretion argument in the Advocate General's opinion, but we have to be guided by what the judgment itself says. And we'll make this point further by showing how Whipple, on the one hand, is contrasted with the Kiel line of authority in Cerro Alonso in next.
Yes.
That's the next way to look at it.
Yes.
The framework. I'd probably pick that up as we go along, I think. So if the court would then look both at our case developing Cerro Alonso and also to the judgment in Cerro Alonso, that would be helpful. In our case, we deal with this at paragraph 160, and I think it's tab 40 in bundle 3. Okay. Bundle 3, tab 51. It should be said that this is a case under the fixed-term workers directive rather than the part-time workers directive. That is not a point of any importance because you find an entirely cognate provision to clause 2.1 in the fixed-term workers directive, and essentially the recitals are the same. The fixed-term workers directive is to be found in tab 122 in volume 6, and it may be helpful to have that open at the same time. I'm going to make good this point. Tab 16, sorry, not 16, what should I say? 20. Thank you. 22.
Yes.
Yes.
Is it tab 20?
See,
tab 20.
if you have a finger in 20, which is the part-time workers directive.
Oh yeah, right.
There are many, many similarities between the two. It's essentially the same construction. And the scope in the agreement to the fixed-term workers directive, which is clause 2, is in identical terms in clause 2.1. The issue in the case was whether the claimants who worked for the Basque Health Service as part of temporary regulated staff were covered by the fixed-term workers directive. Ms. Del Cerro Alonso applied for a length of service allowance, which was provided for in the relevant law, but she was refused it on the basis that it was paid to permanent staff but not to fixed-term staff who, as it were, had a period of contract, then were laid off, and then were re-employed, and then were laid off, and so on. Now, what happened was that on the reference to the Court of Justice, the Kingdom of Spain argued that because they were not described as employees in Spanish law, these workers, they were outside the scope of the Fixed Term Workers Directive. That was the argument that the Kingdom of Spain adopted. And one can see this being considered in the opinion of the Advocate General, which is at paragraph 8 and following, and that is at page 149. The scope of the directive is defined by clause 2.1. This agreement applies to fixed-term workers who have an employment contract or employment relationship as defined by law, collective agreements or practice in each member state. The Court has had occasion to examine that provision in its recent case law, and then it's clear from those decisions that provisions of the Framework Directive can apply to fixed-term employment contracts and relationships concluded with the public authorities and other public sector bodies. It's established the concept of fixed-term workers for the purpose of the Framework Agreement encompasses all workers without drawing a distinction according to whether they're employers in the public or private sector. It nevertheless remains to be ascertained whether it's necessary to make a distinction according to the status and nature of the relationship between public authorities and the bodies and their staff. 9970 applies to contract staff of public authorities. Does it apply to regulated staff of those same authorities? In order to answer it in a positive manner, the National Court invokes in the grounds of its decision-making reference the broad definition of workers in the Court of Justice's case law on 76207. That's the Sex Discrimination Directive, the Equal Treatment Directive. 11. The Court has held that there's no single definition of worker, see Martinez Sala. Thus, it is established that in regard to equal treatment for male and female workers, the concept of worker is an independent concept. It is therefore possible that officials may be regarded as constituting a particular category of workers. On the other hand, it's apparent that in the area of safeguarding workers' rights, where undertakings are transferred, in which the directive adopted is intended to achieve only partial harmonisation, reference must be made to the definition adopted by the national labour legislation. Consequently, if under that legislation a public law employee is not the subject to labour law, he cannot be considered to be a worker within the meaning of community law on transfer of undertakings. And then 12. It is true that the directive expressly makes reference to national law. However, it seems that the case law does not consider such a process to be decisive for the purposes of interpretation. The Court has held in the context of 93-104, the Working Time Directive, that the concept of working time constitutes an independent concept of community law, which must be defined in accordance with objective characteristics, see Keel. Conversely, the Court has held in an area closely related to that, the issue in this case, governed by the Framework Agreement on Part-Time Work, that workers come within the scope of that agreement where they have a contract of employment or relationship as defined by the law, collective agreement, or practices in force in the member state, citing Whipple, paragraph 40. That difference in the treatment of references in social matters arises from the way in which the matter is approached, depending on whether the Court of Justice attaches more importance to the purpose or to the scheme. As far as the organisation of working time is concerned, the Court of Justice points out that the directive in question pursues a fundamental social objective, guarantee better protection and health of workers. Consequently, although that directive is limited to laying down minimum requirements for that purpose, only an autonomous interpretation is capable of securing for that directive full efficacy. On the other hand, both in regard to transfers of undertakings and in regard to part-time work, the Court, and there's a brackets clause, contrary to various things, essentially accepts that the directive in question is not intended to establish a uniform level of protection. In those circumstances, it must be acknowledged that the concept of worker is defined exclusively by reference to the applicable national law. In this case, I propose to adopt a slightly different approach. In principle, it is right to respect the wording of the Framework Agreement, which leaves to national law the responsibility. In this instance, it's apparent from the file that the claimant is not being subject to labour law, does not enjoy under the national law concerned the status of a worker. It will be for the national court to satisfy itself that that is the case. That assessment cannot, however, be carried out in isolation from any consideration of community law. It must be borne in mind that the framework established by the Framework Agreement is intended to prevent, in a general way, abuse arising from the use of successive fixed-term employment contracts. It may be inferred from that the member state must define and interpret the concept of workers referred to by that agreement in such a way as to comply both with the objectives and with the general principles of community law, in particular the fundamental principle of equal treatment. That conditional renvoi appears to me to be the process which is most faithful to both the letter and spirit of the community legislation. The effect is that the member state cannot merely rely on the formal or special nature of the rules applicable to certain employment relationships in order to exclude the latter from the benefit of the protection afforded by the framework agreement. If that were the case, there would be grounds for concern that the framework agreement could be rendered completely redundant. If it were the case, it would be open to any member state to make the contract staff of public authorities subject to special rules in order to call in question the decisions adopted by the court. Consequently, the exclusion of public servants from the scope of the directive cannot be accepted unless it's demonstrated that the nature of the employment relationship between them and the administration is substantially different from that between the employees falling according to national law within the category of workers and their employers. The file appears to show that the Supreme Court has had occasion to rule on the content of the special relationship characterising the ties between a civil servant and administration in the field covered by this case, rendering that relationship incomparable with the situation of workers who do not have the status of civil servants. However, it's for the National Court to assess to what extent that assessment is consistent with the conditions laid down in community law. Now, I pause there for a second. We say we'd win on that alone,
Yes.
but actually the court went further, did not accept the Whipple and Peak line, but did accept the Kiel and Jaeger line.
Well, time is running rather close to the time we have to rise. Can we go very quickly to the court? I've turned
Yes.
on to
It's
page
paragraph 24 and following,
Yes,
and the key paragraph is 29.
yes.
The mere fact that a post may be classified as regulated under the national law and has certain characteristics is irrelevant in that regard.
Yes.
So, otherwise, in reserving to member states the ability to remove at will certain categories of persons
Yes.
in the framework agreement, the effectiveness of the community instruments would be jeopardised, citing Kiel at 58 and 59.
So Kiel is in effect approved. and,
Kiel is approved and applied in the context of fixed-term workers,
Yes.
and we know part-time workers is the same provision. And so we say
I
that
think-
brings to an end the discretion argument.
Yes, I
essentially.
think just reading through the answer to the first question, you can see that being applied in the way they answer that
It is.
question.
It is, that's right. So we say that really is dispositive of the discretion argument in this case.
You said that there was another decision in the last few days, I thought.
Yes, and that's, there are two other cases, one called Impact, which we cited in our case, and there was a judgment last week called Bruno and Pellini, I think it is, or Pettini.
Is that in the,
And what
loose
those
sheet?
two both do, in the fixed-term workers context and in the part-time workers context, is show, not in the construction of clause 2, but in the non-discrimination provision, that it has to be interpreted in what I would call the European context and not by national law.
Yes.
And it does that by going through all the recitals and the legislative context within which that takes place. I'm sorry, you're about to ask me a question.
Well, I think we've been told about the Advocate General's opinion in
Bruno
Bruno
Pettini.
Pettini, but the court has now pronounced, has it?
It is, and I'd like
Do we
to...
have that?
We do, and if I can show you that very shortly, it would, if even without reading it to you, that might be a point to conclude.
Where do we find that?
Would you allow me
Yes,
to
yes,
do
please.
that?
Yes.
Bruno and Pettini is in the folder
That's N, I think.
at
Is
N.
Yeah.
I'll say immediately the facts are horrendous. They concerned whether or not somebody with a vertical cyclical contract working for Alitalia was suffering discrimination. A vertical contract is somebody who works a full day but only works part of a month or part of a year. So they're part-time in that sense, not part-time in the sense of only doing part of a day. The question was whether the prohibition on discrimination in relation to employment conditions in Clause 4 of the Part-Time Workers Directive also covered pensions. That was the issue in the argument. The substance of the judgment is paragraph 22, and you'll see a cross-heading at 24, the substantive scope of the framework agreement. And this essentially does the purposive work which I was referring to earlier. You see in 25, in accordance with the objective of eliminating discrimination between part-time workers and full-time workers, Clause 4 provides, in respect of employment conditions, part-time workers not to be treated less favourably, therefore necessary to ascertain whether the provisions governing the pension rights of Alitalia constitute employment conditions. That was the issue. In adopting the directive, the Union based its decision on the Agreement on Social Policy concluded between the Member States of the European Community, annexed Protocol number 4 on social policy, annexed to the Treaty establishing the European Community, in particular Article 4.2, which provides that agreements concluded at European Union level are to be implemented in matters covered by Article 2. The provisions of the Agreement on Social Policy were reproduced in Articles 139 and 137 respectively. I'll show you the key parts of that, or at least show you where to find them. The matters thus covered include in the second indent of Article 2.1 of the Agreement on Social Policy working conditions, provision which is reproduced in 137 as amended by the Treaty of Nice. It's not possible on the basis of the wording of that provision of the Agreement on Social Policy, or that of Clause 4 of the Agreement alone, to determine whether the working conditions or employment conditions referred to in the two provisions respectively encompass conditions relating to factors such as the remuneration and pensions at issue. In order to interpret those provisions, it's necessary, in accordance with settled case law, to take into consideration the context and objectives pursued by the rules of which that clause is part. See by analogy impact, which covers exactly the same ground but in the fixed-term workers' directive. It's apparent from the wording of Clause 1A of the Framework Agreement that one of the objectives of the agreement is to provide for the removal of discrimination against part-time workers. Similarly, the second paragraph of the preamble to the Framework Agreement states that the agreement illustrates the willingness of the social partners to establish a general framework for the elimination of discrimination against part-time workers and to assist the development of opportunities for part-time working on the basis acceptable to employers and workers. That objective is also stated in Recital 11. The Framework Agreement, in particular Clause 4, thus pursues an aim in line with the fundamental objectives enshrined in Article 1 of the Agreement on Social Policy, which are set out in the first paragraph of Article 136, the third recital in the preamble to the TFEU, and paragraph 7 and the first subparagraph of paragraph 10 of the Community Charter. And if your lordships will keep a finger in there and turn tabs M, first of all.
Oh, how much longer are you going to go on?
2 minutes.
Just 2 minutes, right. It's just before you turned out, it struck me that paragraph 32 was quite important because that's picking up Cerro Alonso.
Well, I can read through and then go back to 30.
Yes.
Moreover, the first, so I just conclude the sentence.
Yes.
Those fundamental objectives are associated with the improvements in living and working conditions and with the existence of proper social protection for workers, directed at improving working conditions for part-time workers, ensuring that they're protected from discrimination as evidenced by recitals 3 and 23. And then we can see in 31, first paragraph of 136 defines the objectives with a view to which the Council may conclude agreements, and that includes the right for all workers to a fair remuneration sufficient for a decent standard of living for themselves and their families, among the objectives which the contracting parties have undertaken. In light of these objectives, Clause 4 of the Framework Agreement must be interpreted as articulating a principle of European law, social law, which cannot be interpreted restrictively. And then you'll see the citation from Cerro Alonso, passage that I've already read.
But do those generalities give us anything that we haven't got from the other cases?
Well, Cerro Alonso is a fixed-term workers case. This is a part-time workers case. And what it comes down to is that those generalities which show that there is a European social policy provides the fact, provides the premise for the argument that, in essence, there isn't a domestic discretion, a wide domestic discretion in implementing Clause 2.1. The paragraphs in 30 are at L and M, the key parts of them, and that might be a good moment, but your lordships will see them at M in paragraph 7 and paragraph 10. In particular, paragraph 10, every worker of the community shall have a right to adequate social protection, whatever his status and whatever the size of undertaking in which he's employed. So that's particularly cited in paragraph 30 as being part of the purpose of the directive. 7 is also cited. And then at L, it's a very short point, the recital that is cited is affirming the essential objectives, the constant improvement of the living and working conditions of these peoples. So that's the context. There's much more in this which it really develops that theme, but I think it would not be appropriate to try and read that to your lordships tonight.
No.
So in summary, what we say is, Sir Alonso, the court takes the Keel approach, not the Whipple and Peak approach, but even the Advocate General's approach would be sufficient for us in this case, because the Advocate General said in terms that you can't exclude, that there is no discretion to exclude employment relationships which are substantially the same or workers having employment relationships substantially the same as other employees. You can't exclude that. The approach taken by the court was even more restrictive, going straight down the Keel line.
Well, I think we should leave it there for today. How are you getting on? Because you've got 0.25 hours left, I think, on your timing.
My Lords, I think essentially covered the directive in its context. I haven't shown you all the recitals, but in a sense it's picked up in this. I would have thought I shall be a relatively short period of time on the regulations themselves. I have to make a few submissions on that, but not at any great length, because if I win on the directive, and if the court holds that there's either an employment relationship or a contract of employment, what the regulation says doesn't matter in the end.
Are you saying the points act clear in your favour?
We say now it has become clear in our behaviour once one reads Sir Alonso and takes that on board, which, as I confess, I was not aware of Sir Alonso below. Yeah. And once one sees Bruno and Bettini, that we say now...
If, on the other hand, the court thought it appropriate to refer the matter, is there a clear statement of the question?
Well,
I'm not asking you to answer that now, but perhaps we could have a clear statement of it.
We've done our best.
You've done your best in your case.
In the case, we have set out what we think is an approach to the question, but there is no agreement between us on that.
Mr. Kavanagh, as far as timing is concerned, you asked for 3.5 hours, and we've got that tomorrow. I take it you're content. Yeah, thank you. Well, we look forward to seeing you at 10:30 tomorrow morning, Mr. Allen, and hope that you can compress your presentation enough to allow Mr. Kavanagh his 3.5 hours. Thank you.